This is Chris Brown from NorthStar Law Group. Here's a clip from a presentation I gave in front of the Tumwater Chamber of Commerce on February 19th, 2020, outlining whether rental real estate qualifies for the 20% deduction under Notice 2019-07 as it relates to Internal Revenue Code Section 199A. I hope you enjoy.
Now, I imagine a few of you actually you're in the rental real estate businesses. You might have like some rentals out there on the coast. Do you get that deduction? And that was a kind of a big hanging question, because does that activity rise to the level of being active? So that answers the question, it might. It might, as always, it might. Now granted, if that's all you do during the entire year, then you're more than likely able to get that deduction. It would qualify as active trader business, and you'll get qualified business income treatment. Now, if there's kind of a squishy thing you don't quite know, there is a safe harbor. That actually came out last year as well. So what you need to do is actually show the IRS that you're actually involved in activity. One, to qualify for safe harbor, you actually have to keep separate records for each business rental activity that you do. If you have multiple rentals, keep accurate records for each rental activity. The second one is you actually have to have at least 250 hours per year of doing stuff related to that rental activity. So actually, if you have multiple properties, you actually could aggregate those though. So it's not just limited to each property. You could actually aggregate that business. The third one is you actually have to document and keep contemporaneous records for each property. I mean, what are you doing with them? How are you doing? What activity are you doing? Basically, how many hours are performed, the description of services performed, who's providing those services, and the dates on which those services were provided. Basically, you have to keep accurate records. It's kind of like if you're driving your car for business, you actually have to keep a log of your hours to make sure you get that deduction. It's kind of the same thing, at least in my opinion. So when I say 250 hours, the safe harbor does not apply if you're actually using the real estate for your residence, at least any time during the year. If you use it for your residence, you do not get the benefit of the safe harbor. Or you actually rented it out to tenants on a triple net lease basis. That's basically where the tenant is in charge of all of the expenses that go along with it. You do not get the benefit of the safe harbor. Now, what do rental services mean when you're calculating the 250 hours per year? Could go to advertising, spending time advertising it, negotiating and executing leases, verifying information regarding your tenants. Do they qualify? Are they good tenants, bad tenants? Rent collecting activities, and the list goes on and on. But basically, if you do those things, then those should be able to qualify for the safe harbor. Now, even if you do not meet the qualifications for the safe harbor, that does not necessarily mean that you do not get the benefit of qualified business income treatment. The thing is that if you want to take advantage of that, you still have to report that position that you're taking on your tax return each year, but you're leaving it up to the IRS to decide yes or no. So it's best if you can to try to qualify for the safe harbor if you must.
Thank you for watching. If you would like to learn more or would like to schedule an appointment to discuss your particular legal issue, please reach out to us by phone or email at your earliest convenience.